Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible Shannon Bell, a Colorado construction lien law expert. Today's webinar topic is getting paid faster with liens, bonds, and contracts. So without further ado, I'd like to introduce the fabulous and wonderful Shannon Bell.
Thank you, Jessie, so much for that introduction. Thanks to everyone who is listening in and watching today. Hopefully you will end this presentation with some golden nuggets of information, we'll say, that you can use to help yourself get paid, whether you are a general contractor or a subcontractor. Please note, if you have any questions, please use the GoToWebinar chat box on the right. We're happy to answer any questions at the end. Just again, please do not include any specific names or company names in those questions. Let's just keep them generic. Quick roadmap of what we are going to cover today. We're going to go through a couple of contract protection clauses that I'd like you to be aware of. Particularly, I'm seeing some of these in my practice that have kind of had a reemergence that have been a little bit quiet until past years. Basic steps for securing your lien rights, some lien exceptions to be aware of. If you have a payment bond, what you can do to secure your bond rights. Disburser notice, although I should probably change, I'm going to talk about that disburser notice in conjunction with the lien rights. Waiver languages, your conditional, unconditional waiver, and then want to make sure that you end with today's presentation with some of the amazing SunRay resources that are available to you. So with that, let's just jump right in. We're going to talk about some contract protections. Hopefully, if you are a general and you're hiring your subs, you're being hired by an owner, or if you're a subcontractor, even a supplier, the lawyer and me, please get it in writing. Get those written contracts. There's a lot of protections in those. However, there's also some problems in those contracts that can do a bit of a gotcha if you're not paying attention. Some of the two that we see a lot, and these are the ones that have been a bit quiet in my practice, but I'm seeing a reemergence of these, are your pay when paid or pay if paid clauses. Pay when paid. You may be familiar with these. What that does is it's really creating a timing issue. And it's saying that general contractor does not have to pay the subcontractor until they receive payment from a project owner. Again, this is a pay when paid. And so it's basically saying within X amount of time of getting that payment from the owner, then the general contractor will pay the subcontractor. You're not seeing that used, however, and most courts are rejecting it being used as a condition precedent before paying the subcontractor. What does that mean? Well, it means even if the general does not get paid from the owner, it is still obligated to issue payment to the subcontractor, material men, or suppliers within a reasonable time. We're going to compare that now when a paid if paid provision. Now this is one where it does allow a general contractor to withhold payment until paid by the owner. Colorado courts, we're here to talk about Colorado today. The enforceability of these provisions can vary from state to state. So if any of you are working in a different state, be aware. But that the subcontractor will be paid only if the general contractor is first paid by the owner, and that the subcontractor bears that risk of the owner's non-payment. How does that work? You're going to typically need to see express language in the contract where that subcontractor knowingly and willingly puts its ability to be paid from the general contingent upon payment from the owner. If you're not having that clear and express language, Colorado courts are going to interpret that as a pay when paid, which doesn't make it an absolute condition to receive payment from the owner. Just be aware of them. It can really tie up the subcontractor's timing of when they get paid by the general, and they can really slow the process. Prevailing party clause. These, again, a prevailing party clause is saying in the event of a dispute, who the prevailing party is going to be entitled to their legal fees and costs. Why does that matter? Well, in Colorado, we're an American rule state. Those of you yawning along saying we don't really care about all the nuances of the law, this one you do care about. And what this means is unless you have a contract that is allowing you to recover your legal fees or a specific statute which allows you to recover your legal fees, you cannot recover them in the event of a dispute. That's pretty important if, as a subcontractor, you are going against the contractor who hasn't paid you, and you are incurring legal fees to assist you in getting paid. And if you are rightfully owed funds, those have not been submitted to you, unless you have one of these types of prevailing party clauses in your contract, you're not going to be able to recover your legal fees. And if you have, let's say, $20,000 in dispute and you expend 10 to 15 in legal fees, now you're netting, $5,000 to $10,000 on a $20,000 dispute. That's painful. You want to be able to have this prevailing party clause in your contract. The other clause to be aware of is an arbitration clause. An arbitration clause is going to say, in simple terms, a court cannot hear your dispute. Now, what disputes are subject to that arbitration clause is going to be defined by the language in the clause. The broader the clause, the more that the issues are going to be subject to arbitration. This can be good. Arbitration typically will happen quicker than court. It used to be less expensive. Anymore, it's about, I think the costs end up being about the same. It's helpful in that it can get you in front of a neutral to resolve the disputes that is binding, generally faster than you can in court. The problem with an arbitration clause, you have to pay more upfront. You have to pay an arbitration fee. You have to pay the arbitrator an hourly rate. Those costs, you tend to see more of those on the front end. But again, if you're going to be in litigation in front of a judge or a jury, those costs are going to be more drawn out. You're not paying a judge, you're not paying a jury, but there tends to be more filings you have to do in court. So the time and money you spend with your attorney on those additional filings is going to be kind of a wash between the fees you're going to pay for arbitration. The thing to be aware of is if you, in conjunction with a claim to get paid, a breach of contract, there is, and you have a lien right associated with that, an arbiter cannot foreclose a lien. So what does this mean? Is if you're trying to get paid and you've preserved your lien rights, often you'll have to bifurcate resolution. Go to arbitration, get a finding on the amount you're owed, then use that to support that the liquidity, the amount of your lien is no longer in dispute, which will then allow you to initiate that foreclosure proceeding in court. So with that, let's jump right into liens. Liens, man, these can be a powerful tool if used correctly, but they are not the end-all be-all if just kind of depending on the facts and circumstances. So important to know about liens, but important to also note that they may not always be your fastest, most efficient road to recovery. In order to secure a lien in the state of Colorado, you must, there is no wiggle room. The lien statutes are very strict. You've got to record that lien. By recording it, it has to go with the clerk and recorder in the county where the real property is located within 4 months of the day on which the last labor or material was furnished or supplied. Note, when you're under a contract, that last day is going to be tied to the last day of substantial work in compliance with the scope of the contract. Now, a few minutes ago, I reminded everyone it is in your best interest to have a written contract. The reality is not everyone has a written contract. You can have an oral contract. You can have a contract by course of performance. When I'm talking about the recording within the last date of the 4 months of the day and the last date that material or label was furnished in substantial compliance with the contract, just be aware, even it's better to have that written contract, but if you have another form of contract, it's still going to be protected under your lien rights. What you're not going to be able to do is extend your lien rights by punch list. If you're a material supplier and there's a purchase order for $40,000 worth of framing material, and as a supplier you go, oh goodness, our lien rights expired last week. Let's just go deliver some screws that are part of the framing package, and that's going to extend our lien rights. Not going to work. So really need to be paying attention to these deadlines. Not only must you record that lien within 4 months of the last date of work or materials are supplied, you have to give notice, minimum of 10 days before that 4-month deadline by certified mail or personal service in order to protect that ability to record on that 4 months. And then after you have properly noticed a lien, you've properly recorded your lien, you must initiate the lawsuit to foreclose that lien within 6 months of the last date of work. Let me show you a quick kind of gotcha, need to watch out for yourself calculation on these lien rights. Let's assume your last date of work is January 11th. That's substantial completion. That's really, you've looked at it every way you can, and that's the safest date you can argue your work was performed. Okay, and you start calculating 4 months. And in Colorado, it is 4 months. It is not 120 days, it is 4 months. So January 11th, February 11th, March 11th, April 11th, May 11th. Your 4 month in this scenario falls on Saturday, May 11th. You're like, no big deal. I'm going to calculate my 10 days. 10 days is May 1st. I'm good. If you send, under this scenario, your notice of intent to lien on May 1st, you have, and do nothing else, you have just now blown your deadline to record that lien. Why? Because that lien deadline is on Saturday. You're not going to be able to record your lien on a Saturday. It's only on a Monday through Friday. That's another caveat. Make sure to check the requirements of the clerk and recorder in the county in which the property is located. There are different options available nowadays, depending on the county, as to how and when you can record your lien. Some have online, you can do an online recordation, but in order to do it online, you may have to work with a third party. You may have to have an account set up. You can still do it in person in some counties, but then they often have limited times they're open. Some will allow it by mailing. If you're going to mail it, you want to be able to track that mailing and allow time for it to be mailed in prior to that 4-month deadline. So as you can see, lots of nuances that go into calculating that 4 months. Really need to be on top of it. In the scenario I have here, if your lien, your substantial completion is January 11th, pull back up the last business day of that 4 months. So here, May 10th is going to be what you're going to want to use to calculate as the last day you can record your lien. Of course, all of this is waiting till the last minute. My preference is if there's really an issue with getting paid, you should be starting this process no later than the 3rd month. Here's the reality. Those of you listening in, most of my clients have been in this. They're at the end. They get the work done on January 11th. Gosh golly gee, we're waiting with the owner. Just a couple more payments. February 11th. Hey, where's my payment? We're outside of 30 days. I need to get paid. I know. We're wrapping up a couple of things. In those 2 to 4 months, after the payment, that last payment has been submitted, can go by really fast with lots of promises of, we know you're owed, payment is coming. And even though there may be those conversations and you are relying on those, you don't want to jeopardize a relationship perhaps that you have with a general contractor or an owner. If you are a GC, those are not going to extend your lien rights. When it's coming, when that 4 months is coming up, get in front of it, get that notice out, and get it out sufficiently in time. When you are filling out the notice of intent to lien, it is a 2-page document, or you can do it as a front and back of one document. It's going to be on legal size paper. At the very back of page 2 is an affidavit of service or mailing prior to filing the lien statement. You're going to do the notice. The first thing you're doing is the notice, saying, hey, I'm owed this money. If you don't pay me in 10 days, I'm going to record the lien. When you're sending out that notice, we're going to go through the important information in the notice here in just a minute. Do not fill out this affidavit of service. You are going to leave that blank until that 10 days. After your 10-day notice period has expired, that's when you go back in and fill out this affidavit of service right before recording that lien. Okay, now let's go back into the lien itself. Really important to get your information correct here. You're going to have to properly identify all owners and general contractors. You're going to have to properly identify the property, including a legal description, and properly identify the amount owed. Do not overstate. What do I mean by that? If you're like, well, I invoiced $12,000, but I'm kind of angry. I'm going to give them my little kind of putative extra fees I don't usually charge. I'm going to record that lien for 13. You've now intentionally overstated the amount you are owed. One way to invalidate a lien is that it is overstated, and it not only can it invalidate the lien, but by statute, you've now exposed yourself to paying the owner their legal fees and costs by intentionally overstating the lien. So be real careful on that one. Now, on the lien itself, what are those points I was just walking you through? What are the really being careful here? You want to make sure you identify yourself on your lien claimant. Make sure you've got the owner, reputed owner, identified correctly. You can do a lot nowadays online, looking at the Secretary of State, looking up Zillow. Zillow will link you to county websites often where you can get a legal description and the owners. Make sure you put in your address. Let the owner know, are you a subcontractor? Are you the principal contractor? You're restating who you are again. Putting in that legal, putting in that legal description of property, as well as the street address. And again, you're identifying yourself. I know it's redundant, and then putting in the amount that you are owed that is not overstated. There's going to be the certificate of service. Make sure you mail this statement of lien, in particular if you are a subcontractor, to every address that you have for that principal contractor, for your GC. The address in the contract, go to the Colorado Secretary of State. If they have a different address for the registered with the Secretary of State, put that on. It is better to mail this to 2 or 3 addresses for the general contractor than one bad address. Same thing for the owner. If there's more than one owner or reputed owner, mail a copy to everyone. Better to be over-inclusive on this statement of lien than to be under-inclusive on who receives it. Okay, so now we're kind of talking about your general lien, when to tracking your time, who to send it to, what to include in it. Are there exceptions to this? There are. You cannot lien public land. So if you're under contract for example, Denver Public Schools is the owner, they've hired a general in turn has hired you as a subcontractor, that's public land. You cannot lien it. If you are a general laborer, that you have a tightened time frame. You must record that lien within 2 months. look at the contract. Sometimes there's a waiver of lien rights in the contract. There are times when those can be invalidated as against public policy. It's going to depend on certain things like the sophistication of the parties. Well, you want to watch out for that before you sign a contract. There's a homeowner's exception if you are doing work for a homeowner, and this is limited only for homeowners. If you are doing commercial projects, this will not come in. But let's say I'm the homeowner. I am building a custom home. I hire a general contractor. My contract is for $1 million. And the contractor, you're a subcontractor, and you're owed $100,000. And you say, I haven't been paid. Hi, Shannon Bell. I'm going to record your property. I, subcontractor, did $100,000 worth of work on your beautiful new home that you are now living in and enjoying. It's not fair for you not to pay me my $100,000. So I'm going to lien your property. I get to come in and say, I had a contract with the general contractor for $1 million. Here's my proof of payment. I paid the general contractor $1 million. You do not get to lien my property. It's not fair for me to pay for that work twice. Go chase the general. That's a homeowner's exception. It is recognized and it will prevent you from liening that property. Notice extending. If you are in that scenario I talked about earlier, you're within maybe you're in that last month window leading up to the 4 months where your deadline is ticking away to record your lien, and you think you're really close, or maybe you're not close on getting a resolution, you can record. So you can record with the clerk and recorder's office in the county where that real property is situated, a notice extending your lien right. That's going to buy you time. It's going to get you past that 4 months. And the beauty of it, you don't have to mail it to anyone. So if you're concerned that you're going to kind of upset the apple cart by sending a notice of demand for lien, because you're just within a week or two of getting paid, this is a nice way to protect your lien rights. And unless the owner is checking title, they might not see it, and then you can come back in and dismiss it later. Substantial completion. We're talking 4 months, 4 months, 4 months. However, if the project is abandoned, that substantial completion date you're still going to have your 4 months, but substantial completion is going to be deemed 3 months after abandonment. There are some of those lien rights that are tying to substantial completion. So just be aware of that nuance. The disburser notice. Oh man, this can be a handy tool. Sometimes it might not do much, but sometimes it's really helpful. If you're getting checks, you know where the bank is who's issuing payments. That's going to be your disburser, right? Whoever is releasing payments on the project is deemed the disburser. You can do a notice to disburser if you are a lien claimant. So do you have to record your lien? No, but you have to stand in the shoes and have all of the rights of a lien claimant. And then you can send a notice to the disburser, who can be the lender or anyone else financing the project, on saying, before you release those funds to the general, I get my cut as a subcontractor or supplier because I'm owed money. This can really get the general contractor's attention. Apologies to you general contractors listening in, but if you're not paying your subs, they have the right to be upset. But this is going to the lender is going to take these serious, because if they issue funds in violation of a notice to disburser, that lender can become liable for paying you the amounts that you are owed. I'm going to move away now from lien claims. I'm going to talk briefly about bond rights. A bond is going to come into place if it is work on a public project in excess of $100,000 for Colorado state projects, $50,000 for local. My recollection, I apologize that I can't, if it's been updated, it's $50,000 for federal. But anytime you're doing these projects, instead of having those security rights through a lien, you do it through the bond. There are also times on a private project, especially pretty large as far as the dollar value, where the owner is going to get a payment bond. Excuse me. So that's another scenario where you have a bond claim. So instead of recording that lien, you are going to do a notice of claim under the Colorado Statute 3826-106 and 107, saying I am entitled to be paid. You send it to the bond agency to get that payment. Note, you have 6 months after the completion of a project to initiate legal action on a bond claim. So be aware of that if you are doing those public projects, or if there's a payment bond. If you want to do a quick screenshot, this is just an example of your verified statement of claim, what that's going to look like under your bond claim. The other thing to be aware of under your projects is our lien waivers. There's a couple of different types of lien waivers. You've got your progress payments, so you've got your conditional or your unconditional. Your during construction progress payment, conditional waiver. The general reaches out to you, or the owner reaches out to you as a general and says, hey, sign this conditional waiver, I'll give you your payment, but you gotta do the waiver first. And those are pretty typical, those are fine. And that's just gonna say, I'm waiving my lien rights conditioned upon receipt of the payment referenced herein. And those are, again, you tend to see those as there's ongoing draws. An unconditional waiver is saying, I release my lien rights no matter what. Those can be pretty problematic. Don't want to be releasing your lien rights in the middle of a project unless it's conditioned on getting paid and limited to the scope of a work that you've performed through that date. You don't want to be releasing lien rights for work in the future that you have not yet been paid for. And then, of course, you've got your end of construction, that final payment. Similar philosophy there. You're going to do that conditional. Here's your final payment, including all retention. And the owner or the general contractor says, yep, do this waiver and then we'll pay you. And you want to have that condition that that waiver is tied to actual receipt of that payment. And then the unconditional one is as after you've been paid in full. You're going to want to wait until you're paid in full on those. In the interest of time, I'm not going to walk you through the rest of these slides. I believe these are going to be made available for you. It's just reiterating what I've told you, the difference between those conditional and the unconditional. Conditional tied to actually being paid. Unconditional is whether you've been paid or not. And with that, hope that you have enjoyed today's presentations and happy to open it up for questions as we're coming up on the top of the half hour.
Well, Shannon, as always, you are spectacular. Thank you so much for all of that information. One little tidbit I do want to just kind of add on to that last section about, the waivers and releases. Please, please, please be aware of what it is that you're signing. If it is a release provided by your customer to you, most likely it is going to have language in there that's going to benefit them and protect them. So just be aware of what you're signing. Make sure if you haven't received the funds yet, or you've received a check but it hasn't been cleared yet, that you're doing a conditional release. Please make sure that it has that correct language on there. If you are on the SunRay system, our releases are going to have that defaulted in there for you to protect you guys. As far as questions, we do have a couple of questions that have come through. The first one, it says, do the deadlines for my lien change if the lien is contested or disputed?
No, great question. The deadlines for your lien do not change if it is disputed. The fact that it's disputed is even more reason to get that recorded and to protect your right. If they weren't disputed, a lot of people would not have the need to record a lien in the first instance.
Would it affect the deadline to have to move forward with a foreclosure suit or anything else?
It does not. Any dispute over the validity or the amount owed on the lien is not is not going to impact the deadlines for recording the lien. It is not going to impact the deadlines for initiating and moving forward with a lien foreclosure. Now, one thing to be aware of in that 6-month lien foreclosure deadline, oftentimes if as let's say, and I'm assuming on a subcontractor position, let me just go through it on a subcontractor scenario for the purpose of the question. Typically, if you have a subcontractor that is not getting paid on a project, again, typically in a commercial project, or maybe sometimes in a larger or smaller residential project, you're typically not alone. There are typically several subcontractors and or suppliers who are not getting paid. If just one of them initiates a lien foreclosure action, they're supposed to list everyone else who may have an interest in that foreclosure action, which would be triggered by anyone who has recorded a notice extending or have recorded a lien. And whoever files first, everyone else can jump into that lawsuit, and they'll be able to relate that 6 months for initiating the action to the first party who filed the complaint.
Okay. All right. Wonderful. Thank you. Another question that came through: as a supplier, if I canceled a lien so my customer could receive their next draw, and I sold another or more material before the lien ran out, can I refile the lien?
You can refile a lien, and I want to make sure I understand the question properly. So if you are a supplier who is doing periodic submission of materials to the project, a lien was recorded in order to allow disbursement to the owner, but then you were not paid in full for that. Can you re-record the lien? Yes. However, you have to start the whole process all over again. You have to do the notice of intent all over again to be safe. The other thing you can do is, and it's a little bit of a variation on that, is if you record a lien and the amount that is subject, maybe let's say you record a lien for $200,000 and you are paid $100,000, instead of starting the process over, you can simply amend your lien statement to reduce the amount you're owed to avoid that excessive lien being recorded against the property.
Okay, wonderful. Thank you. The next question that I have, it says, if I am a supplier to a subcontractor and it's for a job for a condo association, do I need to send the notice of intent and the lien to all unit owners or just to the condo association?
All unit owners.
All unit owners. Okay, wonderful. Thank you so much for that clarification.
Yeah, and I just want to do a caveat on that. We didn't talk about it today. The thing to be aware when you're doing a condominium project, in particular if there's starting to be sales of the units, is whether you have the right to a blanket lien, which is over the entire property, or whether you can only record it against particular condos. And that is going to be tied to whether the work you performed and the materials you supplied can be reasonably allocated between specific units, and if not, then you have the right to do a blanket lien on the parcel as a whole.
Okay, all right, awesome. Thank you so much for that clarification. And then another question, is monthly service work considered lienable in Colorado?
It depends on what the work is. The general rule is if work is being done for the improvement of real property, that's going to be your trigger for a lien. If you are, for example, a maintenance person who's coming in and checking on the property, just doing general service work, unlikely that would satisfy improvement to real property for the basis of doing a lien. If you are out there doing monthly service, you're maybe a landscaper, and every month you're coming out, you're pruning trees, you're taking, maybe removing dead flowers, or planting new flowers, that is likely to meet the requirements of an improvement to real property such that it is lienable.
Wonderful, thank you. And then I think this is the last question that's come through. And I think you kind of touched on this during the presentation. If the lien deadline falls on a holiday, do you have to record it the Friday before, or are you extended until the day after?
the Friday before.
Perfect.
Always,
Thank you
always,
for that clarification.
yeah, you're always going to want to, if ever in doubt, you roll backwards if it falls on a weekend or a holiday. Do not roll it forward.
Yeah. Well, and try your best to not wait until the very last minute to do that. Like Shannon discussed, make sure that you guys are getting those liens set up and looking into if that's what you need to do by, the third month of making sure that you guys are protected and not waiting to that last moment. All right, that is all the questions that have come through. If you do think of a question that wasn't addressed, please feel free to reach out and I'll be sure to answer any questions for you. Shannon, can you go to the next slide for us? Here are some of SunRay's resources to help you stay organized, know your deadlines, secure your lien rights. So go ahead and scan that QR code to access these incredible resources. There's a lot of really great information on there. So please feel free to utilize it at your convenience. All right, and then the next slide. All right, our next webinar with Shannon is going to be Wednesday, May 7th. The topic is going to be what happens after I record my lien and how do I get paid? So please go on to sunraynotice.com/education to register for free. We'd love to be able to see you there. And then next slide. All right, and if you don't mind, take a moment to give us a review on Google. We really do appreciate all the feedback. So scan that QR code. It takes about a minute or so. We'd love to hear your thoughts. And then the next slide. With that, that is all we have for you guys today. Thank you so much to everyone that was able to attend. We hope to see you guys at our next webinar. I hope you all have a wonderful and beautiful sunny day. Thank you so much again, Shannon. You really are remarkable. Thank you. Bye.